The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Hello, y'all. My name is Judge Chris Dillon. Welcome to North Carolina Court of Appeals. We have one case on the calendar today. It's Dunbar versus ACME. And on the panel today is Judge Lucy Inman and Judge Reuben Young. And so each side will get 30 minutes, and we will first hear from the appellants if you're ready. And let me know if you want to reserve a little bit of time at the for rebuttal.
Your Honor, I am going to ask for 3 minutes for rebuttal.
Okay, perfect. Okay, I'll keep up with your time. You can begin. Thank you.
Thank you, Your Honor. May it please the court, I'm Seth Bernanke from Mecklenburg County, representing plaintiff appellant Derek Dunbar. Mr. Dunbar was injured in 1998. This is an accepted workers' compensation claim. He settled his indemnity claim in 2003, leaving his claim open for medical benefits, which the agreement pledged to provide. The defendant stopped paying medical compensation in 2013. They did not notify plaintiff, and he did not know they were not paying for the treatment that he continued to get. This case is to decide whether an insurer can close a case for an injured worker who's getting medical treatment and believes that is being paid for. When it turns out his reasonable belief is wrong, can he be kicked out of the system and lose his benefits without even knowing it? In that way, this case is one of first impression in this state. In none of the other cases cited in the arguments was the plaintiff continuing to get medical benefits. They had either stopped payment of indemnity, had not been getting any more treatment. This is the only case in which the plaintiff was continuing to get medical benefits, believed it was being paid for, and had his medical benefits cut off without notice. This decision will have ramifications not only for Mr. Dunbar, but for many in his position. If the decision is that no notice to plaintiff is required, carriers will have a strong financial incentive to simply stop paying medical compensation and see if anybody notices, or if anybody finds out within the 2 years. And if you don't notice, if they don't find out, then that's too bad. All their medical compensation is gone. In workers' compensation claims, the insurance carrier pays the bills, but the injured worker gets no explanation of benefits, no receipt, no any indication that either all the bills been paid, some of the bills been paid, or none of the bills been paid. And that's the crux of this case. 9725.1 allows the statute of limitations on medical compensation to expire 2 years from the date of last payment of medical or indemnity compensation, but it doesn't say anything about notice. My argument focuses on why 9725.1, read in pari materia with 9718 subsection H, requires that notice be given to the plaintiff before the 2 years limitation in 9725.1 can run.
Could you go, let me interrupt. Tell me why this case is different from some of these other ones like Lewis versus Transit Management. Did your client believe that he was incurring medical bills that the defendant was paying for? Is that what he believed, or?
Yes, sir. And as a matter of fact, that's what the deputy commissioner and the full commission so found based on the stipulated facts in the case. And it was found in finding of fact number 4 that he didn't know that they weren't paying, and it was reasonable that he didn't know that they weren't paying. And that was based on the facts that were stipulated to by both parties.
Was there any representation that they were being paid, or would he just never found out that they weren't paying? I mean, what?
He never got any kind of notice or any kind of indication that these bills were being paid. He continued to go get treatment, and they continued to provide treatment for him. So the other cases, like I said, the other cases were where no medical treatment or indemnity was being paid at the time when the statute started to run. And what you might be referring to is Hunter against Perkins.
That's right, yeah.
In which the court found that the Form 28B notice was a reminder and not a notice. Well, in Hunter, the woman had signed an agreement saying that she was getting this final payment of indemnity, and she got a final payment of indemnity. If a person gets a check, they know they've gotten a check. If their doctor gets a check, they don't know their doctor's gotten a check. There's a big difference there. And so in the Hunter case, the Hunter court said that she knew that she'd gotten a final payment, and therefore Form 28B was only a reminder and not a notification. Of course, they didn't go into any statutory interpretation, and on their own, they turned the word in the statute, notice, into reminder, which is not what the statute actually says, but that's another point altogether. But she had actual notice, and that's what the court referred to, and that's where the phrase that the 28B is a reminder, not a notification, came from. Unfortunately, that's been cited several times since then for the same proposition with different facts. But in each time that Hunter has been cited, as I said, that plaintiff in those cases were not getting any further benefits, either medical or indemnity, and that's another reason why this case is different.
So, Mr. Bernanke, just so I'm clear with regard to the facts of this case, so your client never received any information from the medical provider that payments were not being made?
He paid a small co-payment, same as he had paid when the case, before his indemnity case was settled. He was used to doing that. It was not anything new for him. Okay. And so therefore he had no way reasonably of knowing that they had stopped paying.
Okay, all right, thank you.
And just to follow that up to make clear, once there was this agreement going forward, did he still have to pay his copay?
He was still paying copay, yes, Your Honor.
Okay.
If you look at the stipulated facts and record page 11 and 12, he paid a copay before and after.
Okay, so then that's finding of fact 4, I think.
Yes.
Okay, very well. So he's paying this copay going along, and the compensation that he's receiving until I think it stopped in 2013 is paid to a medical provider. It's not paid to him, right?
Correct.
Okay. So unlike the plaintiff and Hunter, it's not like he was used to getting a check in the mail and all of a sudden they stopped coming, right?
Right. He had closed his checks, his indemnity compensation many years prior.
Many years prior to this. So
10 years, yes.
10 years prior. So 10 years after his indemnity stopped, he hasn't gotten a check in 10 years, but he's getting this medical compensation paid and doesn't get any notice that that's going to be changing.
Same doctor, same treatment, same copay, everything's the same. But the insurance company decides to stop paying and they don't bother to tell him about it.
Did the medical provider raise any concern that we're not getting paid by the insurance provider, or were they refusing to pay, or were they not being billed, or what were the findings there? Remind me of that.
Medicare, Judge. So, I mean, the medical provider, it's like water flows to, wherever gravity takes it. If a provider's not getting paid from one source, they just get it. If there's another source, they can get paid. They don't really care.
Right. Okay. That's what happened.
So, okay.
When you said that this is a case in first impression, I just want to make sure I'm clear. There's not a case previously decided in which a worker who was receiving indemnity and medical compensation, the indemnity ended year 1, and for 10 more years, the medical compensation continues. And for those 10 years, this person isn't getting a check, isn't getting anything. And you're saying we haven't had another case like that.
The other cases that I've talked about, the notice, have been cases where the plaintiff has stopped seeking and stopped receiving either indemnity or medical compensation. So there were no benefits being sought, and I guess the Court of Appeals was thinking, well, he has no reason to think that there's something that's still being paid.
Because he's not seeking this. He can not seeking the treatment, but here, unlike that, he's continually seeking the treatment.
That's correct, right? Okay, so the idea of my argument and the focus of the argument is that the statute requires notice to the plaintiff when 25.1 is read in pairing material with 18H. If this court does decide that the statute does not require notice, then it becomes a constitutional issue with due process question. But my argument is focusing on the act itself because I realize the Court of Appeals is reluctant to tackle a constitutional issue when it's not necessary. And the argument is that it's not necessary to look at that. But if this court decides that the act does not require notice, then it does become a constitutional issue because it deprives the plaintiff of a vested benefit, the medical compensation, without due process, without notice, an opportunity to argue for his rights.
Was there any evidence of why the defendant was just refusing to pay? I mean, was there any? Did they provide any reason why they weren't doing it? Or didn't come up. I'm just.
Your Honor, there's a voluminous record there, and my recollection, and I'll be frank with you, I can't remember whether this is in the record or not, is that the carrier said they didn't receive any bills. They stopped receiving bills. So, you know, it's kind of a blind willfulness because they knew he was getting medical treatment. There was no indication that he stopped getting medical treatment, but apparently the doctor decided to, or the doctor's office decided to stop sending the bills, or the pharmacy decided to stop sending them bills. It was easier to get paid another way. And so the carrier willfully decided, well, that's okay with us. And we'll wait for 2 years and that'll be the end of it.
If I could just follow up on Judge Dillon's question. So if the pharmacy stops sending bills to the carrier and the doctor stops sending bills to the carrier, why would the carrier know that Mr. Dunbar was continuing to receive medical treatment?
Well, he'd been receiving treatment for, let's see, since 1998 through 2013. That's 15 years. His injury was acid that was poured on both feet. It's a lifetime injury. It's not something that goes away. As a matter of fact, as you get older, you're not going to get better from the acid burns on both feet. He had been having consistent medical treatment for 15 years. I mean, it's hard to imagine under what circumstances they could have said, oh, well, he's better and he's not seeking treatment. They just decided, well, we're not getting bills. We don't need to pay anything. In 2 years, the case will be over.
Well, and I'm sure we'll hear a different perspective from Mr. Jones in a moment. But I guess what I'm trying to focus on is you're arguing that the statute requires notice, and that really is an equitable issue. That's just, this statute requires notice. It's read impaired material with 9718H. But the equitable argument you're making, or the practical argument that, hey, how was this guy supposed to know because he never got the checks? I could see the insurance company saying, you know, we have so many people that we're paying compensation to, we can't remember this guy's case at all. And if you look at it as between two parties, the doctor dropped the ball, a third party dropped the ball. Who's going to bear the consequence of that? And your argument is that because this statute, read impaired material with 9718H, requires notice from the insurance company, the consequence is on the insurance company to let the patient know. Is that right?
Well, they're the only ones in the position within the workers' compact to know.
Right.
And they make a decision about when last payment becomes final payment, which is something that I'm sure Mr. Jones is going to discuss. The defendant's argument is that notice is not required under 18H until final payment has been made. When does last payment become a final payment? The last payment we know because it's on the insurance company's ledgers. Well, they paid this and this is the last payment. It becomes a final payment when there's a decision by the insurance carrier that they're not going to pay any more medical compensation. Either they don't have a bill or they've got a bill and they're not going to pay it. That's when it becomes the final payment. What they're arguing is that it's not final until the statute is run 2 years later. If that's the case, what good does notification do? I mean, it doesn't help a plaintiff to get notification. Oh, well, you used to have medical compensation benefits, but they're gone now.
But doesn't Lewis say that the final payment is just the last payment that was made, and that been interpreted for us already, and we're bound by that?
Well, it says last payment is not. I think it says last payment is not necessarily the final payment. My argument is that it's the insurance company's decision if that last payment is the final payment. If when there's no more payments to be made, and if you look at the Form 28B, it has a box to check: is this last payment the final payment? And the insurance company has to make a decision. If it is the final payment, they need to notify on the 28B. The Industrial Commission's Form 28B is page 1 of the appendix to my brief, and it shows it's entitled "Notification to Plaintiff of Additional Medical Compensation." So, if there's a notification that you have a right to something, it has to be notified before that right goes away.
I guess what would happen if the defendant didn't know that it was going to be? The defendant doesn't know when the last time that the plaintiff would go to the doctor, and the plaintiff just didn't go for 2.5 years, and they never checked they wouldn't have checked the box. Or are you saying? I know your case is different, but would you say in that case the plaintiff could continue to be compensated? Because the defendant wouldn't know to check the box because they don't know when the plaintiff is going to stop seeking medical treatment. And
Yes, Your Honor. If you have something, a medical problem that could be continuing and is not closed, sometimes you may not go to the doctor for a while, and sometimes you may. The question is, does the plaintiff need to be notified before the statute runs? And technology today is very simple. If there's a payment made, there could be a tickler in the computer for, say, 18 months. And if there's no payment within 18 months, then Form 28B would be automatically generated and sent to the plaintiff. You have 6 months to pursue this right if you want to. And then if another payment was made, then that would push the tickler another 18 months away. It's very simple. Almost everybody has programs that can do that. So it's not really a difficult thing for an insurance carrier to do. But the onus should not be on the plaintiff, because the plaintiff doesn't know what's paid or not. The plaintiff can go to the doctor today. The doctor might send a bill 3 months from now to the carrier. The carrier might pay it another 6 months from now. There's no telling if he goes back to the doctor once a year or twice a year for an MRI or something like that. He has no way of knowing when that time will run.
Okay.
I hope I've answered the question. I'm not sure that.
No. I agree. Your case is different from the facts that I presented, because the statute says that if the payment within 2 years, the employee has to file with the commission application for additional medical compensation. I know your client thought that he was continuing to go to the doctor and getting and it was getting paid. I understand your case is different. The statute does though seem to put the onus on the employee to file something generally if they're not going to the doctor for 2 years.
Can I ask you just and I understand you explained that very well, and it makes sense that your first argument is that statutory construction requires this notice, and then you argue that if it doesn't require this notice, there's a constitutional challenge. Can you address the insurance company's argument that we have no constitutional claim here because Mr. Dunbar has no property right? It's more like having a right to bring a lawsuit, which we know there are statutes of limitations and they just expire. So can you respond to that?
Yes, Your Honor. I think that the right to medical compensation and the right to indemnity compensation are both property rights. They are, when the insurance company accepts a claim, they are bound by statute to provide those rights. Those rights can be sold in terms of closing the case for a sum certain. They can be waived. It can be lost. All those things are true, but it has to be through due process. One I have cited, there's not a specific case in North Carolina that I was able to find that talks about the property rights of benefits through workers' comp, but I've listed in my brief several cases from other states that do find that workers' comp benefits are property rights. And if you look at the Beckler case, which is in, I think, page 30 of the brief, that's a North Dakota case, but they cite Board of Regents of State Colleges against Roth from the U.S. Supreme Court from 1972. And their citation is, the quote is, "Protected interest in property derived from an independent source, such as a state statute or rule entitling an individual to benefits." And that's from 1972, the U.S. Supreme Court. So I would say that pretty much settles the question of whether those benefits are property rights. And in order to take away property rights, you need due process. And due process requires adequate notice to defend those rights. And no notice is not adequate notice. And so the city of Randleman against Henshaw from 1966, North Carolina Supreme Court, says that notice is a due process consideration required under the 14th Amendment to the U.S. Constitution and Article 1, Section 19 of the state constitution. And Trivet against Trivet from this court in 2004 says that whether a party has adequate notice is a question of law. And interested parties with a tendency of the action need to be apprised in order to give them an opportunity to present their objections. I mean, even when you go back to the statute and whether the defendants have talked about Dease and statutory interpretation, it's follow all those rules in Dease and statutory interpretation. What it really comes down to is this is not only the letter of the law, but the intent of the Workers' Comp Act to provide benefits to plaintiffs without depriving them on a technical basis. And if you look at something like Hartzell against Thermoid Company, which is quoted in my brief, our Supreme Court said the Workers' Compensation Act is primarily for the protection of the employee, and he is entitled to know with certainty when his right of action accrues. And if you're not provided any sort of notice whatsoever, how can you know with certainty? Losing medical compensation without notice is really the only right under the Act that a person could lose without ever knowing it. If you have a final payment of indemnity, you know that you've got a final payment of indemnity, but you don't know that medical compensation. There's a list of all the statutes where notices, many of the statutes where notice is required, and they're all throughout the Workers' Comp Act, such as in 9718, the defendants are required to give notice of whether they accept the case or deny the case. They're required to give the Form 19 notice of accident to the employee with a Form 18 that he can fill out to state his claim. In the 9527, let's see. In the statute that allows for cutting off of benefits, they're required to give notice to the employee that has a right from the Form 24 to respond. This notice to the plaintiff is required all throughout. And as I also mentioned in my brief, when 25.1 statute limitation that we're talking about was passed in 1994, and that same session law was 18H, and the 18H amendment amended that statute to say notice to the employee. And those things is not coincidence that those two things were passed simultaneously.
And just technically to get to that analysis that you're making, if this court concluded that the text of 9725.1 was clear and unambiguous, some might argue that we would stop right there. We wouldn't look at another section of the statute, and we certainly wouldn't look at the legislative history.
Well, I argue that it is clear and unambiguous that notice is required, Your Honor. That's where I would come in with that.
So I guess you argue that if you argue that it's clear and unambiguous that notice is required, and Mr. Jones argues that it's clear and unambiguous, that notice is not required, that two opposing clear and unambiguous arguments equal it's ambiguous. If you say that, therefore we then go look at the other section, and therefore we can look at the legislative history.
Well, Your Honor, that's a good point. I guess that would be step two if you decide that it's that it is ambiguous. I'd say that would be the next step in the decision-making process. Yes.
Let me say you have 2 minutes until you eat into your 3 minutes. If you want,
Okay.
just let you know. Just want you to know.
Thank you, Your Honor. I don't know which other aspects of the argument are important to you, so I'll just go. I know what Mr. Jones obviously his argument is talking about, that 9718H compensation refers only to indemnity compensation. And I went to some pains in the brief to show that there are many places in the Act where compensation without saying medical compensation also includes medical compensation. And there's a long list of those statutes that show all the statutes that include compensation, medical compensation, and compensation. If you look at the definition of compensation, 97(2) subsection 11, it talks about not only, it says money allowances paid to the plaintiff. That can be a weekly benefit, but then it might be something else, reimbursement for travel or prescription expenses. It also talks about funeral benefits in that statute as being compensation. And those are reimbursements. Those are not indemnity. So the definition of compensation itself does not restrict itself to indemnity. Then the introductory clause to 97(2)(2), the definition section, says that these definitions need to be considered in the context. So they're not absolute, even if you were to argue otherwise. So, and the question then would be, why would there be a difference between medical compensation and indemnity compensation with regard to notifying the plaintiff that those benefits are being lost? And I would argue that they're both benefits that they need to have and that they need to be able to advocate for themselves. So I think I'll reserve my 3 minutes, and if no one has any further questions, I thank you.
Thank you so much. We'll hear from the appellee.
Thank you, Your Honors. My name is Dwayne Jones. I'm with Hedrick, Gardner, Kinchlow, and Garofalo. Represent the defendants in this matter, ACME Southern, and their insurance carrier. With me off camera is my co-counsel, Michael Hedgepath. I guess to start off with, I want to be clear that I think that plaintiff's counsel and I are clearly starting from two different points. And Judge Inman, you sort of got to my opening statement just a few minutes ago. 9725.1 is not an unambiguous. It is not an ambiguous statute. It is absolutely unambiguous. The language is clear on its face. The terms are defined either by the Act itself or by this court's case law. The context of the statute is clear. And that statute, 9725.1, does not require notice to the employee before this 2-year period starts to run. It does not require notice. No one says it. I mean, it can't clearly provide notice, require notice when it doesn't ever mention notice. Before I get into that argument, I did want to sort of clarify at least 3 points that came up in plaintiff's argument. The first is, and I thought by Judge Dillon, Judge Inman, your questions, maybe you were confused. There was not this continuous, the plaintiff was not continuously required to pay a copay for either his medical treatment or for his prescriptions, going back since 1988. The record doesn't show that. And I think even his testimony is that a couple times early on, he was required to pay a copay or some small cash payment for his doctor. That was not continuous. Prior to 2013, he acknowledged that he never had to pay a copay for his medications. So again, there wasn't this long stream of I'm constantly paying copays that he continued to do after 2013. Again, his testimony was that yes, early on, a couple of times he had to pay a small cash payment.
And when you say early on in that 10-year period?
Yes, I mean, I don't know. I don't know that his testimony was clear. I just know his testimony and the stipulated facts were early on at some point in time, he was required, he testified he had to pay a small cash payment to see the doctor. But that, obviously, if that had continued with his authorized treating physician, the authorized treating physician is acting outside of the act. If his attorney or he were aware that he was having to pay a small copay, he would have been reimbursed for that. That was never brought to the attention of the carrier. So what I'm saying is that it was not a long continuous paying a copay every time he sought treatment. And I don't know that no one knows the explanation other than his testimony as to why he's made that small cash payment. That wasn't brought to the attention of the carrier either. Had it been brought to him, he would have had to been reimbursed, or, again, perhaps the authorized treating physician should not have required anything.
Well, just hypothetically, could it happen that someone who, especially someone who's living with pain and pain management, is required to make a copay, and it's less than $25, and they are not in regular communication with their lawyer. They think the case is over, but they don't call their lawyer to say, hey, figure this out for me. But it's not like his lawyer was there watching that. I guess the practical question I have about why the act should be interpreted as you argue it should be interpreted is, why would this act provide for a lesser right of notice to somebody about compensation that was going to end, that was not directly paid to them, but paid to a third party? Because it would seem like they would be more likely to know that they're not getting indemnity checks, but they wouldn't know that their provider wasn't getting the checks. Can you just sort of explain why that is?
Well, my first response is going to be, regardless of what my answer is going to be, the statute doesn't require it. So I don't know that I have to explain it. But I know that we always try to come up with some justification for what our statutes say. And again, Mr. Dunbar is in a slightly unique situation, but the reason that medical treatment, there's no reason, there would be no need to give notice, is that medical treatment is different than indemnity compensation. You're entitled to it as long as it's reasonably necessary to effect a cure or provide relief. If you need it, you go get it. If you don't need it, you don't go get it. But it doesn't have to be any type of notice. Your benefits, your medical benefits are about to run out. You need to go schedule a doctor's appointment so that you can continue beyond 2 years. If during that period of time you needed it, you would just go get it. If you didn't need it, you would not go get it. Now, again, obviously the testimony here is that Mr. Dunbar, again, I'm not dispute some of the testimony, but he didn't know. He was paying a copay, but didn't think to go tell his lawyer, hey, I shouldn't be paying for this. I don't know. But I don't know that the statute itself is going to provide him a remedy. But again, the statute did give him a remedy, because it gives everybody a remedy. If you stop treating, or your treatment slows down, but you think you may need continuous treatment, all you have to do is go to the Industrial Commission, you file a Form 18M, and you request to essentially waive the 2-year limitation in 25.1. You file a motion with the commission, you get a doctor to say, yeah, he's probably going to need treatment for more than 2 years, and then you don't have to worry about it.
Let me ask you something. I just make sure I understand the statute. So you have 9718H. that requires the insurance company to file this notice. But how does the insurance company know when it's final? I mean, when does it trigger the liability? So suppose, I go to the doctor, but then I don't go for 2 years. I mean, I guess the insurance company doesn't know if it's the last payment or not, but I guess 2 years later, is that when they're supposed to file it? Because they don't otherwise know. Would that be, is that how it works in practice, I guess? I mean, there's two ways I would think an insurance company would make a last payment. One, I made a payment and they haven't been to the doctor for 2 years. Or two, we're just not going to make any more payments. We made the decision today we're not going to make any more payments. And so we probably should go ahead and notify the commission. Is that correct? Am I thinking about it right?
Well, I think I'm going to have to answer you in about 3 different parts, Judge Dillon. And again, just to be clear, number one.
And I'm just talking about 18. I'm not talking about 25. I'm talking about 18 first. When do they have to file? When do they file the notice typically?
Well, again, 9718 only refers to indemnity compensation. That's my argument. It's in my brief. So we're already, you're going to only want to talk about 9718.
Oh, so it doesn't require notice for medical payments, what you're saying?
That's my argument. That's in the brief. That's where plaintiff's counsel and I get into this compensation versus medical compensation argument. And medical compensation is never mentioned in 9718 at all. And again, 9718 uses the term final. When you look at 9725, it says last. I mean, those are 2 different words.
Oh, and in 97-2, which is the definition, compensation and medical compensation are separately defined things. And 97-211 means money allowance payable to an employee or to his dependents, as provided for in this article. And funeral benefits then doesn't say paid to the parties on behalf of the dependent. Does that distinction make a difference?
Judge Edmond, you're getting a little muffled, and I.
I'm so sorry. Can you hear me better?
Yeah.
Oh.
I don't exactly know what your question is. I can confirm that medical compensation is payment for medical bills. Compensation is typically payment for indemnity, but it's money payment made to the employee, directly to the employee. Medical compensation would almost never be paid to an employee unless, again, something got screwed up and he paid something out of pocket that he shouldn't have paid. Then, of course, he would be reimbursed for that medical compensation.
Let's talk about 25 now. I have a question about that. Clearly, I think if the employee goes to the doctor and then waits 3 years and goes again, the employee probably has an obligation under this statute, or at least to go to the commission and say, within the 2 years, I may have to go back again. But I mean, are you saying the way the statute could work is an employee could go to the doctor, keep going to the doctor, and the insurance company could just stop paying and never tell? The employee would have no way of knowing. I guess it'd be incumbent upon the doctor to notify we're not getting paid. But the insurance company could basically, if we just stop paying and nobody says anything for 2 years, and there's no way the employee knows. And in that scenario, the insurance company would be off the hook, I guess. Is that the way that we're to read the statute? And I'm not saying that's the facts of your case, but let's just say your client did get notice and they just said, we're not going to pay, and let's see if nobody says anything for 2 years, because there's no way the employee would know if they're continuing to go to the doctor. Is that right?
Judge Dillon, I suppose your hypothetical is correct. I cannot imagine a scenario where that would happen, simply because, number one, if the employee is going to the doctor, the employee doesn't just, if it's the authorized treating physician, usually those visits are authorized ahead of time by the carrier. Like, you're not going to go treat for 2 years and the carrier is not going to know about it if, in fact, they are authorizing the treatment.
Yeah, but what if they don't pay? What if the carrier just decides, let's just not pay so that after 2 years, we don't ever have to pay anything again? If you have a bad carrier out there that's doing that.
I don't know how you can prevent the bad carrier in your situation. I can tell you that I cannot conceive of a way that a doctor is going to go 2 years without demanding payment, without going back to that employee and say, hey, I've been treating you 6 times this year. I haven't got paid for a single one. You got to get this stuff straight. Now, again, if that doctor never bothered to seek payment, for 2 years, and the employee's going along assuming that it's being paid, not getting authorization from the carrier to continue to go to the doctor, yes, I suppose that would be a way for a bad carrier to sit back for 2 years and then, aha, gotcha, the statute says it. I think the statute would cut it off in that situation. I think then you start getting into your equitable arguments because, again, you have a bad carrier. Here, your equitable arguments won't work because we didn't have a bad carrier. Carrier wasn't doing anything wrong. Carrier wasn't doing anything intentional. The carrier wasn't failing to do it. So
the facts of our case do not require us to make a decision on my hypothetical of a bad carrier, because you're saying there's no finding that your carrier was a bad carrier, by the way I define it. They were getting notice of these bills and they just decided to stop paying them.
That's correct. And the other thing is we never refused any payment. And I think you may have, someone, Judge Inman, had said that before, or perhaps it was you, I got confused, but the defendant never refused any payment. We paid everything that was presented to us. We paid everything that we were aware of that was being authorized.
Well,
we didn't know that he was having to pay this copay. So the
doctor started seeking payment from Medicaid or some other source. Is that what happened?
I believe that's what happened. That's correct. And so he started billing Medicare. No one was billing the carrier. But again, the carrier, again, I think one of you brought this up. I mean, yeah, in a perfect scenario, you could lump every burden that you can come up with on the carrier, and the carrier can sit out there and try to keep track of this treatment and keep track of everybody's treatment and send little reminders to the plaintiff, hey, by the way, you're not treating, are you okay? But the reality is, again, we're authorizing the treatment. If you're coming to us to have it authorized, which is what they should be doing, we know that they're treating. If they're not coming to us to authorize it, I think the assumption is, well, they don't need the treatment because, again, medical compensation. If you need the medical treatment, you're going to go get it.
So go ahead. Let me ask you a question. So you're confessing there is room for equitable arguments, but it has to be the right case, and this isn't it. Is that what you're saying?
I mean, I think the Court of Appeals has routinely, or not routinely, but has maybe routinely would be the word I would use, but it's probably not the correct word. The Court of Appeals certainly can apply equitable principles in a workers' compensation case. Case law does.
That's all I got you. Thank you. Go ahead, Ms. Judge.
Yeah, and I lost my thought, but here oh yes, Mr. Bernanke had suggested that, institutionally, this is really simple for insurance companies. You just have an algorithm or a tickler in your computer system, which is beyond my skill level, that if 18 months goes by since you receive a request for medical compensation from the plaintiff's providers, that you then send the notice that he argues is required by 9718H, and at that time, the plaintiff then files the form that you refer to that they can file to ask for the 2 years to be waived. That would not require the insurer to keep track of the details of any worker's case, right? It's just a matter of time.
Again, hypothetically, in a vacuum, I suppose that you could come up with that mandate and that requirement, that duty, and place it upon the insurer. And if, in fact, that duty were placed upon the insurer, I suppose that every insurer is going to have to do that, or they're never going to be able to terminate benefits. My response to that, though, is if that's your good idea, then go to the legislature and have the legislature put that in the statute or authorize, the commission can come up with that under 9780 and create a rule, and they can come up with that idea. But as it stands right now, this statute, and I think we have to assume for good reason, does not require notice before that 2-year limitation starts. It absolutely doesn't. And again, when you then get into the arguments about 97-18, the in peri materia, those are arguments. I've outlined it in my brief. I don't know how much I can go through it in detail here, but it's a different subject matter. They use different terms. And again, this whole final last thing, if you look at the Form 28B, the Form 28B itself differentiates between final and last. They do not mean the same thing. The 28B says, is this the last payment? And then right beside it, is this the final payment? They would not ask that question if in fact it were, if they were the same term. So these two statutes do not mesh. And so I think one of the points, Judge Emmond, you were making with plaintiff's counsel before was he's arguing it's clear and unambiguous. I'm arguing it's clear and unambiguous. There is nothing in his argument that says 9725.1 is unambiguous. The only way he wants to make it completely unambiguous, because that's how he gets to, if it's clear, you don't use the in peri materia to go to another statute to figure out what it means. So he clearly says 9725.1 is ambiguous, and you've got to look elsewhere to figure out what it means. I'm saying, no. It is clear, you're done. And that's, I think, what I started out with. Yes. You read 9725.1 and you can close your books. Your clerk can finish up the opinion and we're done.
Okay. So let's assume that you're right about that. And that the Workers' Compensation Act, as we construe it, does not provide for this notice requirement. Then we go to the constitutional argument. Is there something different constitutionally between the right to medical compensation that a worker has under, I think it's 97.25, may be wrong, that is different than a right that someone has to bring a claim? I mean, all sorts of claims that are out there in the world are barred by statutes of limitation that don't require, any notice. But isn't the right to medical compensation more of a vested right that should be protected by the due process provisions of our state and federal constitution?
I think I want to go back to, again, what you said while plaintiff's counsel was talking. You seem to characterize my argument that defendant said that it wasn't a property right. If I said, I did not say that in my brief, and if I did, I apologize. What I said was,
I'm sure I misunderstood it. So,
if it is a property right, the only way that he can have a right to it is what the legislature has given him. They're the only ones who have defined what his entitlement to medical compensation is. He doesn't just innately have a right to medical compensation to be paid by an insurer. So in 9725, it defines what it is that he's entitled to, what his property right is. And that property right is any medical treatment that is reasonably related to to effect a cure. Well, in 9725.1, the legislature, in defining what he's entitled to, put a limitation on it. So to sit there and say you're not required notice for some right that the legislature gave you, when the legislature, when they gave you that right, put a limitation on it. So that's what I'm saying is that, okay, what property right has been violated by lack of notice? The property right that clearly expressly stated when it was given to you that this will expire 2 years after the date of the last payment of medical compensation. So no, I don't think that again, I would likely agree that it is a property right. I think it's a property right that can only be defined by the legislature, and the legislature has defined it. And the other thing is and the frustration I had with plaintiff's counsel's argument is, and I stated in my brief, is that if you're going to make a constitutional argument, I think you're going to have to write it yourself, because he didn't go through the analysis, all of the analysis. I mean, the state can infringe upon your property rights if they want to, and they don't necessarily have to give you clear notice. There's a whole balancing factor that goes into it, which neither plaintiff's counsel nor I have discussed for this court. And then the last thing is within that statute itself, it gives you a provision that says if you can waive this 2-year limitation if you go to the commission and put forth evidence. Look, I'm going to need treatment longer than 2 years. So I'm going to need it longer than 2 years. So why don't you just go ahead and say, I get it. And if you do that and you have a doctor that says, yes, I to a reasonable medical certainty, I believe that you're going to need this treatment more than 2 years, you get it. Then you don't, then it's done. Then it's, I mean, I'm not going to, please don't put this in the opinion. I'm not going to, but it's not a lifetime benefit, I would say, but it actually may be. I mean, it used to be, you used to be entitled to lifetime medicals before 9725.1, but again, you can get around the limitation in 9725.1 by simply going and asking the commission, look, I'm going to need treatment. And again, he's been treating, up until this time, he treated for 10 years. So yeah, why don't you just go ahead and get the waiver and then you're clear. And if you don't go get the waiver, that's unfortunate, but I don't know how that becomes the fault of, or you were somehow induced into doing it by the actions of the carrier. Again, we did everything, my clients did everything that they were required to do. They paid everything that was presented to them. So again, I don't understand how that the notice provision in 9725.1 with the remedy is unconstitutional.
Just to make sure that I understand what you're arguing, I'm sure I just misstated before. That's not what you said in your brief. You're saying that the extent of the property right that's vested in this plaintiff is defined in the Workers' Compensation Act, and that definition includes 97-25.1. Says the right terminates after 2 years of the last payment, unless the plaintiff can go and seek relief. What I'm understanding Mr. Bernanke to be arguing is that, and what he says on rebuttal, that the legislature and the Workers' Compensation Act established the worker's right to medical compensation when it's been awarded by the Industrial Commission. And that the due process that's owed to that worker extends beyond what the legislature may have chosen to put in the statute if we hold that is a property right that is not substantively limited by 97-25.1. I mean, we'll hear from him where he's going, but in other words, what I understand you to say is the legislature giveth, the legislature taketh away, and the legislature can define the scope of a property right that someone is given. And I mean, to me, it seems like a question of whether or not the Constitution, in providing a right to due process, can require process beyond what a statute does, and that's happened several times. But it's just I'm going in circles, I know, but you're arguing purely about the statute, and you're saying that there's no constitutional question because it really hasn't been articulated.
That's part of my reason, and again, my attempts to do it. But what you said, the legislature giveth, I would say period, because that's what they gave. They gave him this property right as defined, and they did not need to. No, again, it's practically impossible. Again, what is a carrier supposed to do? Every time they pay a bill, send a Form 28B. because you never know when the final payment is going to be. You only know when the last payment is going to be.
Well, that's not the burdensome thing that Mr. Bernanke suggested. I get your point, but you understand that if this panel agrees with you on the first issue, on the statutory interpretation, that we then must engage in the constitutional. We must address the constitutional issue, right? We can't avoid it, can we? If he has raised this issue on appeal, and we agree with you, statutory interpretation, how can we avoid addressing his argument that the statute is unconstitutional because it denies due process?
Well, I mean, again, I guess that's where I get frustrated with the argument is I don't think that you have been provided with the analysis to go through. You'll have to do that yourself as to, again, the due process violations are, again, the state can infringe upon your due process. There's a balancing thing. What is the right and what is the infringement and what is the benefit to the state and all of this kind of stuff. I think you have to do that analysis before you rule that this statute is unconstitutional. I haven't responded because it wasn't presented to me in his brief.
Is it your position that says that issue has not been preserved for appeal? Or that it's been abandoned?
I'm never one to argue issues aren't preserved, and so again, he brought the issue up. I just don't think he argued it effectively or went through all of the processes that it takes for you to render a decision. You can't just say that. I don't think, again, I'm not telling you what you can and can't do, but I don't think that you can just go, well, hey, the plaintiff didn't get notice, therefore the statute's unconstitutional, period. And I think that's really all the argument he has given you.
Let me ask you a question about 19-18.1. You said it does not apply to medical compensation. I'm reading 97.8-18, which comes before it, and it just talks about compensation. One of the subsections is if any bill for services rendered under GS 9725 by any provider for health care, blah, blah, blah. I mean, it seems to me that a clear reading of the statute would at least suggest that 98-18.1 applies to all compensation. I mean,
no, well, you're right. That is the one provision in there that could provide the medical compensation. I think it's misplaced. I've always thought it was misplaced, but
we didn't put it there. The General Assembly put it there.
What I'm saying is when you read compensation in that statute, within the context of what it says, it's talking about weekly payments. You suspend it when you return to work. All of the other provisions in that statute clearly deal with indemnity compensation. You have found the one instance that says it, that references anything related to medical compensation. Everything else talks about indemnity. And when you look at that, the form about the notice, again, it doesn't. I don't know how that you then take that. Okay, well, hey, we found this one little sliver that doesn't even say medical compensation, but we can interpret to be medical compensation. Therefore, the entire thing applies to medical compensation, and therefore we can go back.
I'm just using the plain language. It says if medical compensation is a type of compensation, and it says payments of compensation, blah, blah, blah. I mean, I'm not saying that you lose because 18.1 applies. I'm just trying to understand why you're saying 18.1 doesn't apply to what in the statute suggests that it doesn't apply, because it is mentioned in 18, and then 18.1 just says payments of compensation without any limitation. And to me, it seems like medical compensation is a type of compensation. I'm just asking.
Well, I mean, again, I think you're going to have to take a broad view of it when you go back to the definitions in the thing, in the 97-2, and then it talks about even within the context.
Okay.
And you look at the way that compensation is used in 97-18, it clearly deals with indemnity. And 97-18H, I think, performs to indemnity. But this goes back to the gist of it, and I think I'm over time, Judge Dillon, so I'm going to try to quickly answer your question.
Wrap up. Yes, sir.
My fallback argument is no, I don't believe it applies, and I don't think that one little mention is going to change your application of 97-18 and impose it upon 97-25.1. I don't think you can do that. but let's say you do. We got to pay a $25 fine. It still doesn't say that we have to give notice to the employee, or we don't. That if we don't give notice to the employee, that the statute doesn't begin to run. It never says that. So I had a concluding sentence, but I'll waive that. And just if anybody has any other questions, like I said, I know that I'm over my time, but I'll do my best.
I'll give you 30 seconds. If you want 30 seconds, you can conclude, and then we'll go. I'll give a little bit extra time to Mr. Bernanke.
Well, all I was getting, plaintiff's counsel is asking you to determine an unambiguous statute is ambiguous. Ignore the clearly defined terms. Read 9725 with 9718 when they don't, despite what our most recent exchange was, Judge Dillon. They don't overlap. They don't apply. They're not read together. The other thing I want to point out is that he wants you to interpret the act to the benefit of the employee and certainty to the employee. But the purpose of the act is also to give a limited and determinate liability for the employer. And, again, I think that's what 9725.1 does. He has a remedy in 9725.1 that he didn't take advantage of. That's not the fault of the employer. And again, even if you get down to the one remedy he points to in 9718H, that means that we have to pay a $25 fine, but it does not mean that the statute did not begin to run.
Thank you for your argument.
Thank you.
Yeah, rebuttal. You can take 5 or 6 minutes. Go ahead, and we may have some questions for you. So we'll go back to the appellant. I think you're on mute. Yeah, there you go.
Okay, thank you. You can hear me?
Yeah, I can hear you now.
Okay, thank you. 9725.1 doesn't say that the employee has to be notified, but it doesn't say that the employee doesn't need to be notified. It doesn't say anything about notice. There are many statutes that have a clause for one thing and another, and they're all related. In this case, Mr. Jones was talking about the right to medical compensation, 9725. And then you get 9725.1 talks about the limitation on that right. And then you have 9718H, which talks about the need for notice on the limitation of that right. To me, those things are read together. That's why 18H was amended when 25.1 was amended in the same session law. The intent is that this all goes together. Why would you need to notify for indemnity when a person gets a check and they know they've gotten it, and not for medical compensation? That makes no sense at all.
Was there any evidence in the record that the defendant received the bills or any bills, or is all the evidence show that the doctors just pursued Medicare or other avenues?
Your Honor, this was decided on stipulated facts. If you'll look at record page 11 and 12, you'll see you have to go on the finding of fact by the Industrial Commission that Mr. Dunbar didn't know and reasonably shouldn't have known that they were not paying. We don't know what's behind the scenes in any fact about what really happened or what might happen somewhere else. Really record, but the finding of fact is based on competent evidence that was stipulated to by the parties, and therefore it's not before this court is our argument. So the remedy of the $25 to the Industrial Commission is a holdover from before the statute was amended. If that's the only remedy there is no remedy for the plaintiff. I mean, what does notice provide but the right to advocate for your rights? And if they don't get that notice, clearly a $25 fine to the Industrial Commission doesn't satisfy the question of a remedy. If there's no remedy at law, then equity comes into play. So. And in terms of filing a Form 18M, he was getting medical compensation. An analogy might be your mom puts mashed potatoes on your plate, big old mashed potatoes. You don't immediately say, I need more mashed potatoes. You're getting the mashed potatoes, and as long as you're getting the mashed potatoes, there's no reason for you to worry about continuing to get mashed potatoes. So he's getting medical compensation. He's going there. No one's notified him that there's going to be a problem. So that's all there is to it. There's no reason for him to go and get this 18M. Those are really the points that I wanted to make. Oh, the compensation I listed on page 12, all the statutes, and there are probably more statutes that are clearly compensation includes medical and indemnity as opposed to just indemnity alone. The statutes that talk about indemnity only talk about maximum and minimum compensation or wages. And those things are clearly indemnity. You don't have a maximum or minimum for medical compensation. But page 12.
Let me ask you a question about 18.1. I mean, I'm reading the statute the way you're asking us to read it. If your client went to the doctor and the insurance company made a payment and then stopped going for 3 weeks and then never went again, wouldn't their final payment would have been more than 3 weeks ago or whatever. 16 days after that last visit, they would owe $25 to the commission, and they wouldn't have. That doesn't seem fair to the insurance company because they don't know if it's a final payment until the injured party chooses not to go to the doctor anymore. So I'm trying to understand what the statute is trying to get at, because it can't mean that, because then every circumstance somebody would owe $25 because they wouldn't know.
Well, the question is, when does the last payment become a final payment? And that's one thing that Mr. Jones didn't address. How is the last payment become a final payment? And he suggests in his argument that it's only final after the case is closed and the plaintiff has no rights anymore. But my response to that is, well, what good does notice do under those circumstances? The last payment becomes a final payment when the insurance company makes that decision. If the insurance company is making a decision that they want to cut off, they're going to close this case, then they decide that the last payment that they got is going to be the final payment, or they're not going to pay anymore. They've got a bill they're not going to pay or whatever. They're the ones who know when that last payment comes to final payment. Nobody knows but them. When they make that decision, then they send out the notice and says, well, the payment for 3 weeks ago that we made is now the final payment. And if you want more benefits, you have to go advocate for them because we're not going to pay.
Okay.
Mr. Jones argued that, if this is a problem that needs to be remedied, it needs to be remedied in the legislature with provisions about the kind of plan that you're talking about. But I just want to ask, assuming that this panel agreed with you that the statute requires notice, what is your response to Mr. Jones' argument that, okay, the statute requires notice, the remedy is we pay a $25 fine, and away we go. No further compensation for you. We've paid a fine, and we've complied with the statute.
Well, if there's no remedy, I would argue that there's no due process at that point. If there's only $25, then they're not going to send the notice. The argument is that there has to be a remedy. Due process requires notice and a remedy. And if there is no remedy, then they've lost their vested rights without being able to effectively advocate for those rights.
And Mr. Jones also argues that you really haven't articulated a due process analysis. There's so many other factors that need to be considered. Do you think the briefing before the court is adequate for us to consider your due process argument?
Well, Your Honor, I'm sorry to disappoint Mr. Jones in my brief writing, but my argument is that there is no notice, and no notice cannot be adequate notice. I mean, by very definition. And there's nothing to weigh. I mean, if there was some notice, is the notice effective? What did they try to do to let the plaintiff know? And then you could balance whether the notice was adequate under the circumstances to balance the interests of the insurance company in cutting off benefits. But there's no notice whatsoever. And so there's nothing to weigh. All the cases say that there has to be adequate notice, and no notice is not adequate.
Well, spend a couple minutes. You can spend a minute to close, and then we'll be done. I'll let you. I'll give you a minute to close.
Okay. Well, Your Honor, I think that in statutory interpretation, the case that the defendant cited in Deese, all those are met. That the interpretation of reading 18H comparing material 25.1 liberally construes the act so that benefits will not be denied by technicalities, but it's not extending the liberality beyond the clearly expressed language of the statute because 18H says explicitly that the employee must be notified. We're not assuming that the legislature left important matters open to inference because they passed those two amendments in tandem in the session law that became the 1994 Act. So it's explicit. And the purpose and the spirit of the Act, again, is to provide benefits without technical denial. And the Industrial Commission, although we're up here because a panel of three disagreed with me, in the 28B, which was promulgated by the Industrial Commission many years ago and revised as recently as 2017, it says on there, notice to the employee of the right to additional medical compensation. And that had to be done through the APA, the Administrative Procedures Act, with all the commissioners involved, and that should be looked at as their interpretation of what the law requires.
Thank you. Thank you for your arguments. Thank you, Mr. Jones. Thank you, Bernanke. Mr. Sewell, will you close court for us?
This session of the North Carolina Court of Appeals is now adjourned.
Thank you very much, Your Honor.
Thank you.
Very much. Good day.
Thank you, gentlemen.
See.